First of all, I'm happy, in fact, and I welcome this opportunity to rise to speak to this important legislation that will protect the integrity of the enrollment process for membership in the Qalipu Mi'kmaq First Nation. But before I outline some of the issues that arose during the enrollment process and explain this bill's objectives, I'd like to take a few moments to describe a bit of history that led to the creation of the Qalipu Mi'kmaq First Nation and to the development of the bill that we have before us today. As some of you know, when Newfoundland joined Confederation back in 1949, the province faced unique issues related to the application of the Indian Act in the province. At the time, there was no agreement between the province and Canada as to if, how, or when the Indian Act system would be applied. In the absence of such an agreement, the First Nations in Newfoundland were not recognized as Indians under the Indian Act, and in the absence of the Indian Act system, Canada provided ad hoc funding to the province to provide social and health programs for the Mi'kmaq of Newfoundland. But that wasn't the solution sought after by the Mi'kmaq.
Of Newfoundland Indians formed with the mandate to promote the health, the social, cultural, economic, and educational well-being of the Newfoundland Mi'kmaq. And their primary goal was to obtain recognition of the Newfoundland Mi'kmaq eligibility for registration under the Indian Act. And from 1976 to 1981, a variety of studies were carried and discussions took place regarding the application of the Indian Act to the Federation of Newfoundland Indians. And after initial efforts to improve relations between Canada and the majority of the Mi'kmaq communities did not result in an agreement. In 1989, the Federation launched a federal court action against Canada seeking recognition under the Indian Act. Now, in 2007, the government settled this court action through an agreement in principle for the creation of the Qalipu Mi'kmaq First Nation as a landless band under the Indian Act, and for its members to be eligible for the same federal programs available to other off-reserve registered Indians. Now, this agreement in principle was ratified in March 2008, Mr. Speaker, by 90% of the eligible members of the FNI who voted and led to the signing of the agreement for the recognition of the Qalipu Mi'kmaq Band by Canada and the FNI in June 2008. Now, Mr. Speaker, the creation of the Qalipu Mi'kmaq First Nation was and remains an important step forward for the Mi'kmaq people of Newfoundland. In addition to giving members of the First Nation access to certain federal programs and services, and this is very important, First Nation status provides a strong foundation for Mi'kmaq cultural growth and development. And as Chief Brendan Shepherd said at the official signing ceremony in 2008, and I quote, "Mi'kmaq people are finally able to claim their birthright, and while we must not forget our history, we must look forward to the future and do the best we possibly can to develop the tremendous potential that exists among our people. However, the establishment of the Qalipu Mi'kmaq First Nation has not been without its challenges. As set out in the 2008 agreement, there was a two-stage enrollment process which ran from December 1st, 2008 to November 30th, 2012. So that enrollment process was over a 4-year period. And the first phase, which ended in on November 30th, 2009, was intended to identify the founding members. And the second phase provided for a 36-month, 3 years, 3-year process to guarantee that all those eligible would have the opportunity to apply and be added to the list of founding members. Now, at the end of the first stage, the Qalipu First Nation Band Order, the recognition order, was issued by the Governing Council, and that was on September 22nd, 2011, establishing an Indian Act band and identifying its members in a schedule. So you have the recognition order, and attached to this there is a schedule listing who these members were. As a result of the recognition order and 3 subsequent amendments that were made to the schedule, 23,877 individuals were listed as founding members, 23,877. And this number represented all those who had applied prior to November 30th, 2009, the end of the first stage of the enrollment process, and who were determined under the original process to be eligible for founding membership as per the 2008 agreement. Now, and that made sense in light of the fact, Mr. Speaker, that the 2006 census revealed that there were approximately 23,450 residents of Newfoundland and Labrador who self-identified as Aboriginal. However, in the second stage, that is the 36 months following the first stage, we saw approximately another approximately 70,000 applications come in. By November 30th, 2012, the date at which that process ended, the deadline for applying, the total number of applications soared to more than 101,000 applicants, with roughly 46,000 of those having been submitted between September 2012 and the end of November 2012. I mean, this in itself is quite telling. I mean, from December 1st, 2008 to the end of August 2012, 46,000 applicants had not yet taken any step in an enrollment process that started 3 years and 5 months before. So at the last minute, about 46,000 people decide that they are Mi'kmaq Indian in Newfoundland, and that they belong to this group. So it was, I mean, you know, you can't just imagine the surprise of the band and everyone when the numbers came in. They were approximately 10 times the amount of initial projection of about 8,700 to 12,000 individuals based on membership data provided by the Federation of Newfoundland Indians, an assessment of historic census data and other estimates. So these figures would have resulted in a single band equivalent to about 11% of all registered Indians in Canada. Almost 70% of the more than 100,000 applicants do not reside in any of the Mi'kmaq communities targeted for recognition in this initiative, but live elsewhere in Canada. Now, this was not at all reflective, Mr. Speaker, of the original intent of the parties as set out in the 2008 agreement, which was that founding membership in the Qalipu Mi'kmaq First Nation would be granted primarily to persons living in or around the 67 Newfoundland Mi'kmaq communities named in the agreement. And while individuals living outside of these communities could also become members, the intent of the parties was that non-residents would be required to have maintained a strong cultural connection with a Newfoundland Mi'kmaq community, including a sustained and active involvement in that community. Now, given these concerns and the fact that there was no time, and this is another important consideration, there was no time to consider the additional applications prior to the end of the enrollment process established by the 2008 agreement, that is November 30th, 2012. So, according to that agreement, if these applications were not processed or reviewed, that ended, so they could not be reviewed. So it was obvious to both Canada and the Federation of Newfoundland Indians that something needed to be done if the integrity of this First Nation was going to be protected. At a minimum, greater clarity about eligibility was required as the process had just become unsustainable. So, the Federation of Newfoundland Indians and the Government of Canada agreed to review the effectiveness of the implementation of the 2008 agreement and look at possible solutions. Now, in July 2013, the President of the Federation of Newfoundland Indians and I announced a supplemental agreement to address shared concerns about the integrity of the enrollment process for membership in the Qalipu Mi'kmaq First Nation. And the 2013 supplemental agreement, which we signed with the Federation, protects the integrity of the First Nation by ensuring that only those with a legitimate claim to membership and registration are enrolled. That's all that we care about, to protect the integrity of that First Nation. And at the same time, it provides for a fair process that ensures the fair and equitable treatment of all applicants in a manner that respects, of course, taxpayer dollars. More specifically, it extends the timeline to review applications, ensuring that all applications previously unprocessed will be processed, since they could not be processed under the agreement of 2008. And second, it ensures that all applications received during all phases of the enrollment process will be assessed or reassessed, except those that were rejected. And this guarantees that all applicants, no matter when they applied in the process, will be treated fairly and equitably. Third, this supplemental agreement guarantees that anyone whose application is reviewed would be sent with notification, and that those who have submitted a valid application would be given an opportunity to provide additional documentation in support of their application. Now, this deadline has now passed. In November 2013, all applicants received one of two letters, okay? I mean, in cases where an application was invalid because it did not meet the basic requirements to be assessed, the letter advised the applicant that his or her application had been denied, simply. The other letter, and about 6,000 people received that letter. Where an application was valid, the letter advised the applicant that he or she can provide additional documentation relating to the criteria of self-identification and group acceptance by January 30th, 2014, which, by the way, we extended to February 10th due to extreme weather conditions in Newfoundland. Fourth, the supplemental agreement clarifies how an application's self-identification as a member of the Mi'kmaq group of Indians of Newfoundland is assessed. And finally, it provides guidance regarding an individual's acceptance by the Mi'kmaq group of Indians of Newfoundland, and this information is particularly relevant to individuals living outside because of the group acceptance requirement back in the agreement of 2008. Now, Mr. Speaker, I want to underscore that the supplemental agreement does not change the enrollment criteria set out in Section 4.1 of the 2008 agreement. The criteria remain the same. As per the 2008 agreement, the applications will be assessed by an enrollment committee, which includes 2 representatives from the Government of Canada, 2 representatives from the Federation of Newfoundland Indians, and 1 independent chair. The enrollment committee will conduct a comprehensive assessment or reassessment of all applications that were not previously rejected in accordance with the criteria for membership that were originally negotiated. Now, it is estimated, Mr. Speaker, that this process will take about 2.5 years, and after which individuals will be advised, informed of the results of the assessment or reassessment of their application. Now, it is possible, Mr. Speaker, that some individuals may lose the Indian status as a result of this process. And those individuals would no longer have access to programs and services provided to registered Indians. Now, in order to implement the supplemental agreement and address our shared concern with the Federation of Newfoundland Indians regarding the integrity of the enrollment process, we will need to amend the schedule to the order that created the First Nation. And, Mr. Speaker, that is why we need Bill C-25. We are asking Parliament enable the Governing Council to amend the schedule of the order creating the Qalipu Mi'kmaq First Nation that lists the names of the founding members. Now, to be clear, I mean, we're not asking to change the order, the recognition order that created the Qalipu First Nation. Instead, we are providing the Governing Council the authority to make changes to the schedule to the order which lists the names of the First Nations founding members. In addition, the legislation would prevent individuals from collecting compensation or damages from either the Government of Canada or the First Nation in the event that, at the end of the enrollment process, they are found not to have a legitimate claim to membership and are omitted or removed from the schedule. Now, I want to reassure you that there will be no change in Indian status for existing members during the review process, and while it is underway, individuals currently registered will retain access to programs and services, and if there are some who are deemed or determined not to be members, there will be no clawback at the end of the enrollment process for the benefits they may have received from the date that they were declared members of the band. So, I ask all members to think of the integrity of that First Nation and also our responsibility to the taxpayers of Canada, because this is at the heart of all of this bill. Thank you, Mr. Speaker.
As can be seen by the question so far, there is considerable interest in this and debate by the Minister so far, considerable interest in this question in the province of Newfoundland and Labrador. And while there might be, Mr. Speaker, given the history of Aboriginal matters in the province of Newfoundland and Labrador, which the Minister himself alluded to and I alluded to in my question and comment intervention, the reality is that Newfoundland's history with Aboriginal people as a part of Canada's history and before is one that is subject to a great deal of historical debate and controversy, but since Confederation has been under the legal regime of the Constitution of Canada and the responsibility of the Government of Canada in terms of its fiduciary role with respect to Aboriginal peoples and its constitutional responsibilities under Section 92 of the Constitution Act. The problem has been, Mr. Speaker, that Aboriginal people in Newfoundland and Labrador did not get access to the same programs, services, funding that was made available to other Aboriginals in Canada, and that has been a source of significant conflict and significant neglect, and historically speaking, a lot has been lost along the way in terms of the advancement and benefits to Aboriginal people in Newfoundland and Labrador. You know, when one looks at a chronology, even produced by the Aboriginal Affairs in Northern Development Canada, there's a big, huge gaps between mentioning 1949 as the time of Confederation and the next entry sometime in the 70s when the first consideration talks about the Innu Nation, the variety of studies and discussions regarding the application of the Indian Act to the Innu in Labrador. Some 25 years later, the Mi'kmaq of Conn River were initially agreed to by the Government of Canada to develop an application and the recognition of the Conn River First Nation in 1984, 34 years after Confederation. So we've had a long period of neglect. In fact, during the negotiations of Confederation, and I took an interest in this back in 1987 when I was first a member of Parliament and had a paper commissioned looking into the terms of union. The resulting paper is called Penciled Out. And that's because during the terms of union negotiations between the Government of Canada and the representatives of Newfoundland and Labrador, there were a series of draft agreements which included, up until 2 or 3 versions in, provision for for Indians that they were then known universally in Newfoundland and Labrador, but at later stages of negotiations that was all removed. And it was removed for various reasons that have been given historically. One suggestion was that they would lose the right to vote if they became recognized under the Indian Act. There were other reasons given for that historically, but the fact of the matter is that they were excluded from the benefits and provisions of services, including non-medical, non-health, Medicare benefits that were available everywhere else in Canada, special health benefits, drug programs, important access to education and other programs that were available throughout Canada to everyone who qualified as status Indians. So this agreement, this Qalipu First Nations ban, is an attempt by the Mi'kmaq to retrieve or to achieve something of what they should have been entitled to going back to 1949. It's imperfect. It's imperfect because it deals with individuals who are still a part of the communities that traditionally had Mi'kmaq populations. The 65, the Minister says 67, I count 65 in the schedule unless it's been amended, that people are still associated with will have rights under this band. They have an enrollment process which has been, as is widely known, resulted in people recognizing that finally, at long last, there's an opportunity for the Mi'kmaq of Newfoundland and Labrador to be recognized generally for their status within Canada as Aboriginal people. Now, this bill itself, and I think the Minister is quite correct, is not about the whole big picture. It's not about the enrollment rules as such. It's not about the qualifications. Those agreements were made by the Federation of Newfoundland Indians on behalf of the various communities and memberships in the various bands throughout Newfoundland that were associated with the Mi'kmaq people and the communities in which they resided. It was ratified by the people who participated in the vote by some 90%, which is a fair indication that with respect to the communities that have been identified here, that there's a wide degree of acceptance by them as to what they hope to achieve by the creation of the Qalipu Mi'kmaq First Nation Band. So that part is the historical agreement that was made ultimately in 2008 with the modifications in 2013. But what we're talking about here is what is the effect? What is the effect of this legislation? What is it going to be on this process? And what is it going to be with respect to those who may be excluded by this process? So we have some concerns about how this is being interpreted. The Minister made a comment that people will still have access to the court, they just can't get damages. The member from Humber St. Barbe Vert has a more assertive understanding of what this is and denying people access to the courts. I think that's something that needs to be fully explored as this legislation proceeds, and certainly we would expect that significant and proper and appropriate legal representation and expertise ought to be applied to this legislation to see whether in fact it does anything more than prevent someone from getting retroactive damages for not being recognized then as opposed to now, or whether it in fact is extinguishing any right or preventing someone from having access to the courts. As the Minister's speech indicated, that the access to the court would be retained for the purpose of a declaration that someone should be included in the Qalipu First Nation Band, should be covered by the agreements, should have access to the benefits. If that's indeed the case, then we would certainly want to have expert opinion on that from people with knowledge of the law and with knowledge of how agreements like this and how other similar types of legislation, how they treat that. Is there some special rules being created here to prevent individuals who may be wrongfully excluded from the band, who get a proper adjudication from the court, from getting the redress that they need? That's something that I would certainly want to have clarification of. The issue of enrollment itself, I think this legislation doesn't change the criteria for enrollment. I think the application of them and the documentation necessary, the process that is to be undertaken to do that seems to have been obviously a misjudgment. The people who negotiated this agreement, and I would say on both sides, the Federation of Newfoundland Indians is represented by their leadership, including Chief Brendan Shepherd. They set up a procedure that they thought would be fair and equitable, and they thought would be adequate to be able to assess and deal with the applications. Clearly, it wasn't. I don't think anybody anticipated that the numbers of people who were applied were going to be in the tens of thousands of people, more than 3 or 4 times more than what was anticipated. And clearly the timelines and the procedure, the committees that were set up, the time that was given in the agreement for processing applications, for making decisions, for issuing these was totally and woefully inadequate, to the point that people were going to be denied the ability to participate in the Qalipu First Nation, Mi'kmaq First Nation band because someone couldn't process their application in the time that was set out in the agreement and all of the legislation. So clearly something had to be done to modify the enrollment process and the assessment of that. The new regime, as it were, as the minister pointed out, with two members of the Federation of Newfoundland Indians, two representatives of the Government of Canada, and an independent third party, is a process that's been agreed upon. They have timelines that I haven't heard any complaints about the adequacy of the time that people have had to apply, although there are still people, I understand, who are learning about this process for one reason or another and still feel that they haven't had an opportunity to be considered. Now, some might say that's because they haven't self-identified as a Mi'kmaq Indian, and they haven't participated and been accepted by these groups as a member. And I think that's something I think we should all give some consideration to, that this is, as the minister said, is not totally, he said it's not about ancestry, but it is about ancestry. But one of the criteria required, among other requirements, is that an individual self-identify as a member of the Mi'kmaq group of Indians of Newfoundland and be accepted as a member of the Mi'kmaq group of Indians of Newfoundland. So this is perhaps, and I don't know if this is the right word, a subset. This is an agreement in relation to a subset of people who are Aboriginal in Aboriginal Mi'kmaq of Newfoundland and Labrador. This subset are people who continue to self-identify as Mi'kmaq, as the Mi'kmaq group of Indians, and accepted by them. And that implies an association with an existing group as opposed to someone who has left. I think it would be grossly unfair and arbitrary and unjust for people who I referred to, such as those who may have been removed from their homes for reasons of one reason or another. It could have been stereotyped reasons of government officials. It could have been the practices of child welfare organizations. It could have been legitimate reasons for child protection that removed a child from a particular home or circumstance or situation that ended up in that individual being raised elsewhere without knowledge of their ancestry and their identity as an Aboriginal. That's something that they may have learned many years later as an adult. It would be grossly unfair for them not to be considered as having an opportunity to identify with their ancestry, their history, their culture, their true identity as an Aboriginal person. So I don't see any real provision for that here. I think that that's something that needs to be addressed and redressed. There are significant problems with that from a moral and legal and entitlement point of view, and I think it does need to be addressed. The minister made some comments which I find encouraging, although I don't see them in the legislation, I don't see them in any of the agreements here, that I think his comments will be taken up by individuals who are concerned about the fact that they have been potentially left out for the future in this with the Mi'kmaq group of Indians as under the Qalipu First Nations band. Regardless, I think, of whatever the criterion are, there has to be a process. And I don't think anybody would disagree with that. If you lay down the criteria, someone's got to decide whether you are in that criteria or whether you are not. Yes, I could agree that it's the failure of the Government of Canada to ensure that there's a process that's available that's going to work, but I think it's also fair to say that neither the Federation of Newfoundland Indians nor the Government of Canada anticipated the kind of numbers that ended up wishing to be considered as members of the Qalipu First Nations band. And I think, you know, I'm not going to denigrate their desire, which the minister seemed to do by suggesting that they showed up at the last minute claiming to be of Aboriginal ancestry. You know, if you're given the history of Newfoundland and Labrador, the history of neglect by the federal government of its responsibilities from the time of Confederation on,
That's right.
you know, it's not surprising that people who the government wanted to assimilate it, wanted to ignore, refused and failed to provide the services that were being given everywhere across the country. Yeah. The non-insured health services, for example, the Innu of Labrador and the Inuit of Labrador denied access to non-insured health benefits that every status Indian in Canada had access to from as long as they existed, as long as they were recognized, but not the Aboriginals of Newfoundland and Labrador. It's a shameful history, Mr. Speaker. It's a shameful history. In fact, I brought attention to that when I was first a member of Parliament in 1987, because I knew of the history of negotiations about Confederation. I mean, I remember the Premier of Newfoundland, Joseph Smallwood, saying we didn't have any Indians in Newfoundland and Labrador. We didn't have any. Well, they didn't have any on paper because they refused to recognize their existence. Right. And yet here we have the Innu of Labrador, the Mi'kmaq of Newfoundland, and now 100,000 people saying that we are of Aboriginal ancestry and we are proud of that and we want to have that recognized. Now, I'm not saying every single one of them meets whatever criteria are laid out. Clearly, they probably don't. But there has to be a process. It has to be fair. It has to be equitable, and it has to come to a conclusion. And I think, you know, to be fair as well, there is a process. There's also a process of appeal, so that if you are denied that you meet the criteria, you do have a right of appeal. There is a time for appeal, and this process will go on for some longer period of time before final decisions are made. So, in the face of this legislation here, we want to know what it's all about. You know, what is it necessary to have this legislation to achieve the creation of this band? Yes, it's controversial, as I mentioned in my remarks to the minister. What is it? What is it with this landless band? You know, what is it with this landless band? We've got 65 communities in which are identified as being Mi'kmaq communities in Newfoundland and Labrador, and they're going to have access to some services and programs. But what about a land-based or resource on which they lived for hundreds of years? There's no role for that. That's something that I suspect was perhaps the only way that they believed that they could achieve any recognition by the government of Canada of their rights. You know, land claims negotiations in Canada is glacial. Glacial. They keep hoping that they will go away. You know, the government seems to keep hoping that the Aboriginal people and their claims will go away. I haven't read the book, Mr. Speaker, but I saw something even very recently, a quotation from Thomas King's book, The Inconvenient Indian. The Inconvenient Indian. He's come to the conclusion, Mr. Speaker, that the whole history of Aboriginal rights in North America is about one thing: land. It's about land. Land that he calls the white man wanted, and that's the major thrust of any policy towards Aboriginals in Canada is about land. In North America, he says, about land. And so here we have a landless band. That says something about what was trying to be achieved here, certainly by the Government of Canada. The Minister says it was the choice of the Mi'kmaq. I doubt very much if the Mi'kmaq said, well, we don't really want any land. We don't need a land base for hunting and fishing and forestry and looking after our families and living on they lived on the land. They lived in these communities as Aboriginal people for centuries. For centuries.
Yeah, they're stewards.
And they were stewards of that land. I see, Mr. Speaker, thank you for reminding me. I have 1 minute left. So, but I'll use that minute to say there are a lot of complexities. There's a lot of negative history associated with this whole process. And I don't think, we don't want to see it repeated in a process if it's not fair, if it takes away rights, if it denies people access to the courts to establish those rights, then we have a significant problem with that. We want to ensure that when this bill is studied, that it gets full consideration by expertise to ensure that nothing is being done here that's going to damage the future possibilities for the Aboriginal people of Newfoundland and Labrador, particularly the Mi'kmaq. But we do want to see the Qalipu band get the recognition and the services and programs and future that it deserves.
Hear, hear. think it's most important that we put this bill into perspective. We cannot lose sight of what the agreements behind this bill are attempting to redress. The legal rights of Newfoundland's Mi'kmaq people have been in limbo since their status under the Indian Act was left unresolved in 1949 when Newfoundland joined Confederation. Exclusion from status under the Indian Act not only denied Newfoundland's Mi'kmaq people access to supports available to other First Nations, but robbed them of recognition of their identity and cultural heritage. The prejudice
caused and the marginalization of many generations meant that many tried to hide their origins, and thus family histories have been lost for good.
Negotiations and protracted legal action over many governments meant this fundamental issue remained unresolved far too long. The most recent phase of discussions to redress the historic exclusion of status for Newfoundland's Mi'kmaq people began in 2002, when the previous Liberal government initiated renewed, good faith negotiations with the Federation of Newfoundland Indians. The talks focused on the recognition of the Mi'kmaq people in Newfoundland under the Indian Act, and after constructive discussions, an agreement in principle was signed in 2007. On September the 26th, 2007, the Prime Minister said, for more than half a century, the Mi'kmaq people of Newfoundland were among the, quote, forgotten people, end quote, as the Congress of Aboriginal Peoples calls its members. They never stopped fighting for recognition, and now, at last, that title can be cast aside. Ratified in 2008, the agreement would create the landless Qalipu Mi'kmaq First Nations Band and ensure that Mi'kmaq people in Newfoundland would be able to achieve recognition, status under the Indian Act, and the dignity denied to them for far too long. The
Liberal Party believes that any bill or any directive or policy implementing accords between the government and the Mi'kmaq Nation must rest on the premise that legitimate applicants must not be excluded from the process.
About the fact that, unfortunately, this bill seems more focused on protecting the federal government from being sued over their mistakes in how it implemented this historic agreement and limiting the legal recourse of membership applicants for the new First Nation. We understand that the government expected far fewer applications than the 103,000 they eventually received. But if the process was flawed, if the criteria or guidelines were problematic, then the fault lies with the Conservative government, not the applicants. It was the Conservative government that negotiated the criteria for enrollment and how those criteria would be administered. That process was set down in guidelines that were appended to the original agreement. Because of the greater than expected volume of applications, last year the government entered into a supplemental agreement with the Qalipu First Nation and the Federation of Newfoundland Indians. Pursuant to that supplemental agreement, the government is now in the process of reviewing all applicants, including those who have already been granted status. While the government asserts that the supplemental agreement does not change the membership criteria, it does change the guidelines for how those criteria are to be assessed. There is no question that these changes will potentially have an impact on enrollment, and that is why a review of all applications, including those that have already been granted, is underway. While Section 10 of the supplementary agreement affirms that it does not affect the status of the Qalipu Mi'kmaq First Nation Band, it could alter its founding members list. As a result, members who do not meet the additional enrollment criteria could lose their band membership and Indian status. The power of Cabinet to remove individuals from the founding members list is confirmed in Clause 3 of Bill C-25 and is one of two substantive things this bill does. The Liberal Party recognizes that both the 2008 agreement and last year's supplementary agreement flow from a nation-to-nation process that must be respected. The criteria negotiated between the parties should be viewed as an agreement between two nations. However, while the government claims that this bill is necessary to implement the 2008-2013 agreements, we are very concerned that the true purpose of the bill is to indemnify the federal government from legal liability for its mistakes during the botched enrollment process. It is this denial of legal recourse to applicants that is of the greatest concern to the Liberal Party. Clause 4 of this bill is clearly designed to shield the federal government from potential liability for damages flowing from their incompetence in implementing the original agreement. Clause 4 states, 4.1, no person or entity has a right to claim or receive any compensation, damages, or indemnity from Her Majesty in right of Canada. Any employee or agent of Her Majesty, a band, a council of a band, or any other person or entity, only because any person's name or any person's date of birth was admitted or removed from the schedule to the Qalipu Mi'kmaq First Nation Band Order. This limitation of access to a legal recourse is causing many to question the legitimacy of this bill. The repeated mistakes and oversights of the federal government through the process to create the Qalipu Mi'kmaq First Nation Band have led to unnecessary confusion and many applicants feeling frustrated and wronged by a process that should have fostered reconciliation about a historic wrong. The Mi'kmaq First Nations Assembly of Newfoundland is preparing to launch a class action lawsuit against the federal government over the constantly changing process for membership in this new band. The process in course seeks to remedy the damage done over centuries, but the mismanagement of this government exacerbates the feeling of victimization among many members of the Qalipu Mi'kmaq Nation. Claim against the federal government for mistakes or mismanagement should not have that legal recourse cut off by this bill. It should be for the courts to decide whether damages related to the enrollment process are appropriate, and not for parliamentarians to prejudge that issue with this bill. Thank you, Mr. Speaker.